We see a wide spectrum of cases in medical negligence. It can be all the way up from injuries such as pressure sores, where patients haven't been turned appropriately and they've developed injury as a result of that, all the way up to your more kind of most severe type injuries, which would be the amputations, brain injuries, spinal injuries, and in the worst case scenario, fatal injuries, which can be where people have been bereaved because of negligence or because they are now in a condition themselves where their own illness has become terminal due to delays in diagnosis. That is quite a common concern that we hear. A lot of people that come to us say that they could never have imagined ending up bringing a claim against the NHS. What I tend to say to those people, first of all, I do point out there are insurance reserves for the NHS. Any compensation that is awarded does not come out of frontline care, it comes out of those insurance reserves. The second thing that I tend to say to people is that the medical negligence sector is not concerned with trying to harm the medical profession. If anything, what we try to do is provide some guidance. The medical profession, like basically any profession, learns from its mistakes, and it's only really by highlighting those mistakes that it can see what to do better next time. I actually used to work on the defendant side myself. I can confirm firsthand there are endless spreadsheets dedicating to try and figure out what they have done wrong, where they are losing money, what they could do better next time. They learn from these cases, and that is a very important part of why they should be brought, and that's what I tend to tell people. Medical negligence cases are subject to a 3-year limitation period, which basically means that you have 3 years in which to issue proceedings at court. The case doesn't actually need to be settled within those 3 years, but it does need to be brought to the court's attention. The 3-year period runs from either the date of incident or it runs from the date upon which you became aware or ought to have reasonably become aware that there had been an act of negligence. There are some exceptions to that. For example, people who lack capacity, they will be subject to different rules. Usually they will be given a much longer period if that period expires at all. And it's the same with minors. Your limitation period does not actually start to run until you reach your 18th birthday, and therefore would not expire until your 21st birthday. In order to make a medical negligence claim, there are 2 main criteria really. The first of those is known as breach of duty. Basically, clinicians always owe their patients a duty of care, and in medical negligence cases we are saying that the care afforded to that patient has been so bad that it amounted to a breach of that duty. It's not enough for us to simply show that the care wasn't perfect. We have to show it was so bad that not even a minority of other clinicians in that same situation would have made the same mistakes. The second thing that we have to prove is that as a result of the breach of duty, you have suffered harm which would otherwise have been avoidable. Once we've got those 2 things together, we can usually make a case for medical negligence. One of the main things that you can do to try and evidence your own medical negligence claim is to pursue the NHS complaints procedure. That's actually a very good procedure that most hospitals and GP surgeries will have in place. In respect of hospital care, there will be something called the Patient Advisory Liaison Service, abbreviated to PALS. They will give you a lot of assistance in bringing a complaint to the hospital's attention and in asking any questions that you feel are appropriate. The document that you will get back from the hospital or the GP surgery following those complaints is usually very helpful to us. Even if the clinicians are denying they've done anything wrong, it helps to provide a very detailed overview of the care that you've received, and that can be incredibly useful to us. In medical negligence cases, there are 2 main kinds of compensation. The first of those is known as general damages, which is compensation that's paid in respect of your injuries. So that's awards for kind of your pain and your suffering, any loss of mobility, that kind of thing. Then we have special damages claims as well. That's your financial losses that have been associated with the injury. So that's things such as loss of earnings, if you needed care and assistance, if you've needed any private medical care, any adaptations to the home, travel expenses to avoidable appointments, anything like that we can factor into the case as well. You can claim for medical negligence on a no-win, no-fee basis. That is indeed the basis upon which we run all our cases here at JF Law. That means that if we do not win your case for you, we do not take a penny. You walk away with no financial loss at all. If we do win your case, then you keep most of the compensation, but there is a success fee charged on the no-win, no-fee cases. The advantages to running the case on the no-win, no-fee basis are that you are subject to no financial risk at all. All your disbursements will be covered by the insurance that we will take out on your behalf, and basically makes a process that would otherwise be very expensive be totally risk-free financially for you.